The next part of our presentation is on liability or fault allocation. And what we're talking about here is when you have multiple entities, and I have to be careful what words I use because the difference between entities, parties, defendants, and it makes a difference depending upon what statute you're dealing with. But we're talking about situations where you have multiple entities who may be responsible for whatever property damage or personal injury that you're talking about. And when you have multiple entities, there's a couple of things you need to deal with. So the issues are, well, first of all, any case, if there's only one defendant or one entity, you're dealing with what's the plaintiff's fault. How does that come into play with what you, or what the plaintiff could potentially recover? It depends upon what state you're in, whether you're a comparative fault state or a contributory negligent fault state. And we're talking about tort claims here, allocation of fault in tort claims. And what do you do when you have multiple defendants? What about immune parties? Parties who did actually contribute to the fault, but they're immune. You can't sue them. And then what do you do with settled parties? Parties who settle out before you go to trial, and you go to trial, you may be the last man standing. You know, what sort of credits do you get for that, or how do you deal with the fact that the party most responsible for the damages may not even be before the jury? So we're going to go through those in South Carolina and North Carolina to see how these four issues work and raise some of the issues. Now, South Carolina, in 1991, we went to comparative fault. The difference to the common law rule, contributory negligence, we'll see North Carolina still follows. If the plaintiff is at fault to any degree, they cannot recover. They're barred from recovery. Well, South Carolina, we said back in 1991, by a court decision, we went to comparative fault. We said that's too harsh, and what we're going to do is we're going to compare the fault of the plaintiff to the fault of the defendant. And as long as, and you have to be careful where you put the equal to or less, depending on whether you're talking about comparative fault or when we get down, talk about joint and several liability. But comparative fault, as if they're more than 50% at fault, they get no recovery. But if they're 50% or less, so they can be 50% at fault, if they are 50% at fault, they recover half their damages, okay? So whatever percentage the jury assigns as fault to the plaintiff for whatever damages they've suffered, you reduce their total recovery by that percentage. Jury finds them 25% at fault, it's a $100,000 verdict, they only get $75,000, okay? So what do you do with multiple defendants? South Carolina in 2005, we passed a statute. It's 1538-15. It's essentially, it was part of a tort reform package. We refer to it as the fault allocation statute or tort allocation statute, different names for it. Essentially, it's a Frankenstein is what it is, okay? They took a proposed model code, and there was a lot of horse trading in the legislature. You had the plaintiff's bar saying, we want this. You had defendants saying, what about this? And they wanted to pass something. It was, the governor said, we're going to have tort reform, we're going to pass it. So they passed something which does a lot of good for defendants, but then when you get to the back end about what happens when you go before a jury and the jury has to allocate fault, nobody's really sure how it works. And this thing is 7 years old, okay? And we've gotten close to getting a decision, but everybody on both sides is afraid of actually getting a decision because we don't know what it's going to be. We don't know if it's going to be better for plaintiffs or defendants. But the good it does, the first part of the statute is it eliminates joint and several liability. Now, North Carolina is different. North Carolina, we still have common law joint and several liability. Every defendant responsible for any percentage of the fault, the plaintiff can seek full recovery from that defendant. And then that defendant has to go and try to seek contribution from other responsible parties. But South Carolina, what we do, we changed it, and it's referred to as a modified joint and several liability. You could have one defendant be found jointly and severally liable, but only if that defendant is assessed 50% or more of the fault. So if you're a defendant, the verdict form, the jury gets a verdict form. If there's more than one defendant for the jury at that time, the jury allocates fault between the plaintiff and all of the defendants. Any defendant who is found less than 50% at fault only pays that percentage of the damages. So if I'm only found 25% at fault, the plaintiff can't come to me and say, you're the one with money, you pay the total damages and then seek contribution. And that's the unfairness to a defendant. Sometimes you may be the only defendant with pockets deep enough to pay a verdict. And so South Carolina has eliminated joint and several liability for defendants who are found less than 50% at fault. Now, here's where the statute starts to break down. The statute says that the jury has to allocate 100% of the fault to all of the parties. And that means the people who are there before them when they render their verdict. That means if you've got immunity, if you're the employer, you got workers' comp immunity, or if you've settled out, or for whatever reason, you're not on the verdict form, then what happens, and we'll talk about how that could artificially raise your percentage of fault such that you could be found 50% or more liable when you're truly not, okay? And then the statute says, got to total 100%, and then it has a provision. You can argue that the fault, there's other people at fault who aren't parties, but there's no procedure for dealing with it. So you can stand up there and argue all day long at somebody who's not here in the courtroom, but the jury can't do anything about it. So that's one issue, and that's where it starts to break down. So immune parties in South Carolina. In general, we're talking about workers' comp immunity. So if you have a situation where the guy's driving a company van, he gets in a wreck. Okay, he's going to get workers' comp because he's hurt on the job. And then he sues the person who hit him. Okay, we call that the third party. You have a third party suit. Well, that third party investigation found out that the company gave him a van with bad brakes. So the company is also at fault. Well, South Carolina has a specific statute that says if I'm the third party and I find out the employer did something wrong, then if I establish that the employer did something wrong, then I get an offset for the benefits that the employee's already received. Okay? Now the problem is you can't sue in South Carolina. You can't bring the employer in as a defendant. You can't sue them. The South Carolina Supreme Court has specifically said that. And so in this case, they said, well, you can't bring them in, therefore there's no way you can establish they're at fault. So even though the statute says you can get credit for it if they're at fault, there's no procedure for establishing they're at fault. So it's a statute without a remedy. So you can't do that. They can't be added to the verdict form, and Supreme Court has said you can't, therefore there's no way to determine that they're at fault. What about a settled party? The first provision, if they've settled, then you get a set-off for whatever their payment is. Whatever the total damages gets reduced by whatever you've already received. Now, one issue we've had come up is, plaintiffs will settle a case under one cause of action, or settle a case and allocate the recovery to one cause of action and then sue you on a different cause of action. Wrongful death, South Carolina sue for wrongful death and survival. They may settle against really the parties probably most at fault, and we just had this in a case that Steve and I had to work through. They allocated all the damages to the wrongful death and then sued us for survival. And so instead of getting an offset of about $800,000, they actually allocated about $100,000 to survival. And we said, this is just not fair. And so there's a case in South Carolina, and we used it, or threatened to use it, went to mediation, settled case. There's a case in South Carolina that says in that situation, the trial court has the right to reallocate the damages to make them fair in terms of the set-off. So the plaintiff's not going to be able to play games to reduce the amount of set-off you can get. The problem is, when we get to the jury allocating fault on the verdict form, it's only the parties that are before them, like I said. You do get a set-off, but what happens is, since it has to be 100%, if that party is not there before the jury, let's say we start off with 4 defendants and they're all equally at fault, okay? 2 of them settle out. By the time you get to the jury on the verdict form, you have, they have to give 100%, you have artificially increased the percentage of fault of those 2 remaining defendants. So you have artificially increased the chance that one of those defendants could be found more than 50% at fault, which means they're jointly and severally liable. So that's a concern, one of the things that nobody knows how to deal with. We know we get the offset, but what about the issue of whether or not you're jointly and severally liable? We just don't know. Let's say, well, why can't you just join them? What if you got somebody or another issue, somebody who could be subject to suit? Okay, you're not talking about immune, you're not talking about settled parties, just other people out there. Construction defect litigation, like I said, there's always other people. You know, we can always get the doorknob polisher. You always bring people in, technically. Well, technically, actually, in South Carolina, you cannot bring a non-named party in if all you're going to allege is contribution or indemnity. Okay? Now, as a matter of practice, we do it all the time because sometimes they'll remain in knowing that they could be subject to suit later on directly from the plaintiff, and we end up settling those cases. But we have had cases where we third party in a non-named party who could be subject to suit, and they get out because contribution to South Carolina, you have no right until you've already paid more than your fair share, and you don't pay more than your fair share until you've settled or verdict's been rendered against you. And indemnity only applies if you have a special relationship with someone. So they can get out of those things. Excuse me. What about immune or settled parties? As we said, you can't bring them in and can't put them on the verdict form. You can argue all day long they're at fault, but you can't put them on the verdict form. One practice is if they were a party and they settled during the litigation, you know, the rules say that every other party has a right to object to that settlement. I mean, the reality is we normally don't do it because there are other people, there are other defendants, other defense attorneys who are settling. But we haven't done this yet, but in certain situations, it may be good to object to the settlement, object to the release of them for purposes of allocation. In other words, you're telling the court you want them to remain in name only for purposes of allocation because you don't want this artificial increase in your percentage of fault and potentially subjecting you to joint and several liability. And another thing we've tried, and I'll talk about in just a minute if I can take some time. This case came up, I was hired we were retained to defend a furniture manufacturer in the Charleston Sofa Superstore fire a few years ago. Remember, in South Carolina, I know Francis, big down in Charleston. We had 9 firefighters who died at a fire at a furniture store. And it was the largest loss of firefighters since 9/11. To the Charleston's credit, the city of Charleston, they hired this Blue Ribbon Commission who came in, looked at it. They issued a 250-page report that just tore up the fire department, the practices they had. I mean, at one point they had 16 firefighters in there with 3 fire hoses. Only one of them had water. Only one of them was charged. They had thermal imaging cameras on their trucks, but they wouldn't use them because the policy was if you broke it, you bought it. And it tells you how there was another fire, a subdivision right next door that had a fire truck there. They had thermal imaging cameras. They looked in, they saw that the gases were coming into the drop-down ceiling. They pulled all their people out. The Charleston Fire Department never did it. And it was clearly the fault, the majority of the fault for why these firefighters died was on the Charleston Fire Department. But they were the employer. They had immunity. They couldn't be sued. So the party with the biggest percentage of fault was never going to be before the jury. And then, there's probably about 15 other furniture manufacturers, and we're going through the case, and they all start settling out. And I had my company had 5 pieces of furniture in this store. Okay, we're a very small player, and we got down to it was myself and one other furniture manufacturer left. And we're thinking, one of us is going to get hit with at least 50% of the fault in this case. So what we did is we filed a motion to join in name only the fire department. We didn't object to the settlement of the other parties, mainly because I didn't think of it at the time. But we tried to do that, and of course, we told our clients probably going to be denied, but it's something we were going to appeal. And we actually there was a mechanism for a third interlocutory appeal in South Carolina. So we'd actually briefed that case. It was before the Court of Appeals. The plaintiffs came to us and settled 9 firefighter deaths for $100,000. So they didn't want that heard. It didn't go before the Court of Appeals. So another war story. Let me go through quickly. All right, North Carolina on the issues. Contributory negligence is still the law in North Carolina. Plaintiff at fault to any degree is no recovery. Now the burden is on the defendant to prove that the plaintiff is at fault. Okay, so the burden shifted on that issue. One thing, North Carolina has pattern jury instructions. South Carolina doesn't. So if you have cases in South Carolina and the attorneys spend all these time drafting jury instructions, it's because we do have to actually draft them. We don't have pattern jury instructions. But the North Carolina pattern jury instruction on contributory negligence tells the jury that if they find the plaintiff is negligent, the plaintiff doesn't recover. And one thing you may want to think about, Renner St. John and I just had 3 weeks ago, I had a trial where this came up in Raleigh. And we never got to the issue. We got a complete defense verdict before we got to contributory negligence. But one thing you may want to think about objecting, if you have that case in North Carolina, you object to that part of the charge because it injects an emotional aspect into what is simply a legal conclusion. There's no need to tell the jury that. But I think they do that to mollify the harsh effects of contributory negligence. Multiple defendants in North Carolina, they still follow common law joint and several liability. 1% at fault, any percentage at fault, the plaintiff can seek to get everything from you. There's a specific case in North Carolina that says that you can join other tortfeasors. So unlike South Carolina, where there's some impediments to doing so, North Carolina, it's fairly easy to join other tortfeasors. Immune parties, the workers' comp statute in North Carolina also has the same provision as South Carolina, but they actually set out a procedure for doing it. When you go to trial, you can name the employer, and it's essentially a name only because they'll never have to pay more than the workers' comp benefits, but you can name the employer. The employer has the right to come in and defend if they want to. Once you name them, they can go on the verdict form, and the jury can determine whether or not they were at fault. And that can help you because you receive an offset for the workers' comp benefits that the employee has received. And then settled parties is similar to South Carolina. We'd get an offset dollar for dollar for what you've already received. Just briefly how it works in other states. Remember I said South Carolina statute's a Frankenstein. There are similar statutes in Florida and Texas, both of which, Texas and Mississippi is more similar, but both of whom have a procedure for allowing you to add immune parties or settled parties to the verdict form for purposes of allocation. And that takes care of the danger somebody's going to be found more than 50% liable. Florida specifically says you can add tortfeasors to the verdict form even if they are immune. Mississippi, I will point that out, Mississippi has a statute that does that now. Brian and I tried a case in Mississippi that was right after they passed the statute, but the law was still in place. They actually did it through a judicial opinion as a matter of due process, that defendants have a right not to pay more than their fair share of fault. And so they had issued an opinion saying that the jury has the right to allocate fault amongst all the potentially at-fault parties.